Welcome, everybody. Welcome to today's episode of the Law of Self-Defense live stream Q&A show. Apologies for being a couple minutes late. We're just getting these live streams spun up again, and there's proving to be just a little bit of a learning curve. Hopefully this is going correctly, and so is everything else. All right. I am, of course, attorney Andrew Branca here for Law of Self-Defense. And as I've stated in some previous shows, our goal for 2025 is to be doing one of these live streams every week, in addition to all the pre-recorded content that we've been producing. That's been very well received by all of you, so that's very much appreciated. But I know many of you also like these live shows. If I can, I'll probably move them a little earlier in the day too. We'll see what happens. The show is probably going to run about an hour, and we will have roughly the first half of that live stream to both YouTube and to our Law of Self-Defense members. After about a half an hour, and I just set my timer to 30 minutes, we will cut off the YouTube stream and be continuing to stream only to our Law of Self-Defense members in their member dashboard. If you're not a Law of Self-Defense member yet, I have to ask why. It's only 99 cents to try it out for 2 weeks. After that, it's still only about 30 cents a day. Check it out, the trial membership at lawofselfdefense.com/trial. One of the benefits you get from being a member is having complete access to the full length of these live streams, being able to submit questions prior to shows that I'll be addressing in the course of today's shows, and being able to submit questions I'll be addressing live. And just do it in the chat, in the comments. All right. So let me refresh my recollection on what we wanted to talk about today. One thing we're not going to talk about today, I'll probably do a whole show on it, but it just came over the transom a couple minutes ago. A news story about a police officer made a traffic stop. The driver was armed, informed the officer that he was armed, and the officer decided to disarm the driver. No indications of any non-compliance or violence or threat from the driver. Just decided to disarm the driver of his legally carried firearm during the traffic stop for purposes of safety, and shot the driver with the driver's own gun while doing this. Horrific on so many levels. But it's there's enough to talk about with that one that I think it's good for an entire show. One of the things I did want to address today is, do jurors have too much authority to decide guilt? This is something that's really been troubling me for years, but I don't think I've talked about explicitly before. We see a lot of convictions. I see a lot of convictions that, to my mind, are the result of jurors being given too much leash, too much authority to find someone guilty and make them vulnerable to decades in prison. The authority of jurors to find guilt is not supposed to be open-ended, and it's not supposed to be ambiguous. It's supposed to be very tightly constrained within very narrow limits. That's why we expect jurors to be a blank slate when they come into the courtroom and not bring partiality or bias in with them. That's why we have rules about what evidence is admissible and not admissible. Because when we say evidence is admissible, what are we really saying? What we're really saying is the jury is going to get to hear that evidence and take it into consideration at arriving at a verdict. In contrast, when a judge rules that evidence is inadmissible, that doesn't mean the evidence doesn't exist. It just means the jury's not going to be allowed to hear that evidence, and therefore it ought not be the basis for them to arrive at a verdict. The rules they apply, the law they apply, is not supposed to be up to the jurors to decide what the rule ought to be. The jurors are supposed to be instructed on the law, and those instructions should be unambiguous. So just like what evidence they're allowed to hear is a constraint on the jury, the law they're instructed on, the law they're told to apply to the facts of the case as they believed those facts to be proven or not proven, those are also constraints on the jury. They don't get to decide what the rules are. They're told what the rules are. They're certainly not told about jury nullification, which is a theoretical power of a jury, but not something they'd ever be instructed on. So the court is supposed to act as a gatekeeper on the facts and the law that the jury is allowed to apply in arriving at a verdict. So it's not supposed to be open-ended for a jury. And too often, I've seen in recent years that either facts are allowed in that ought not be on very basic principles of evidence. We saw this in the George Floyd case. There was a real problem with what's called cumulative evidence. So while George Floyd's being arrested, when he's on the ground, being lawfully restrained after he's ingested a mouthful of meth, has a threefold fatal level of fentanyl in his system, has cardiac metabolic disease, severe disease, decides to unlawfully fight lawful arrest for 10 minutes, all that. Well, when he's on the ground and they're waiting for EMS to arrive, which those officers have already called, and they're just restraining him so he doesn't run into traffic or do something silly. There's maybe a dozen or 15 people on the sidewalk watching all this, screaming at the police officers, which was one of the reasons they weren't able to get George Floyd care more quickly. But they're screaming at the officers. And every single one of those witnesses was called to testify in the trial. Well, they didn't see different things. It's like having the same person testify 15 times in a row. All the testimony is essentially the same. And that's called cumulative evidence. It's giving the evidence a weight it ought not to have simply from repetition. So that's an example of a jury being given facts they ought not have been given. Of course, one witness, two witnesses would be fine. But when you allow the same facts to be presented 15 times over, that's normally not admissible. And we also see problems with the law being instructed. We saw this in the Ahmaud Arbery case, where the whole key to the case, that's the jogger who was shot in Georgia case. The whole key to the case was whether or not the defendants were making a lawful citizen's arrest. Citizen's arrest was defined by statute, but the statute was old. It was about 150 years old. It was ambiguous. There was terminology in it that means different things today because of Supreme Court decisions that happened in the intervening 150 years it said things that had become terms of art that were not terms of art when the statute was created. And what should have happened there is the judge should have made a call on one interpretation of that citizen's arrest statute, because there were competing interpretations. Let's just say there was just an A interpretation favorable to the state and a B interpretation favorable to the defense. And it was the key to acquittal or conviction. The judge should have made a decision. I'm going to instruct the jury that this 150-year-old citizen's arrest statute means A, or he could have said it means B. Either way, I hardly care. But he didn't do either of those things. He said, you know what? I'm going to let the jury decide what it means. That's not the role of a jury to decide what the law is. That's the role of the judge. The jury is the finder of fact, but the judge is the finder of law. So when the judge fails to do that, that's, to my mind, a gross miscarriage of justice. We can't have any confidence in that conviction. And if the judge had chosen the interpretation of the statute that locked in a conviction for the state, that's up to the judge. That's fine. But then that could have been appealed by the convicted defendants, which is what's supposed to happen if there's a dispute over a matter of law. So I think we're living in a very dangerous world right now. Juries have always been dangerous and unpredictable creatures, but now we've let them out of the cage. We're not constraining their access to facts. We're not constraining their interpretation of law, which they're not supposed to be interpreting at all. It's like having a dangerous animal, a lion, a pit bull, in your neighborhood that broke free of the yard, chasing down kids in the street. It's a problem, and it really needs to be fixed. And I'm just a small town lawyer in Colorado, folks, but it would be nice if authoritative figures out there in the legal community recognize this problem and began to advocate for change. Because all we have now is this chaos, and chaos is not due process of law. It's supposed to be a criminal justice system, not criminal justice anarchy. Anarchy. I see someone asking a question here about Pam Bondi. We just actually released a video today on Pam Bondi, her nomination. One of the things I'll do today is I'll go through this past week's content that we've produced, the videos we've posted up for our members and on YouTube, and I'll address some of the open questions that have come in since we posted those up. Let's see. Here's another one. Can talking to the police have a good outcome? I have a video on this. Let me see if I can find it. A little 1-minute short. And this is it. So let me see if I can share this with all of you. And it looks like I can. All right. So if you don't recognize who this is one of my personal heroes. This is Massad Ayoob. The same Massad Ayoob who wrote the foreword to my book, The Law of Self-Defense. Been a friend of mine and a professional colleague for 30 years, 29 years, I think, this year. Ever since I took his week-long course on use of force and use of force law. Back then it was called Lethal Force Institute 1. The first level course was a week long. Back in 1996 is when I took that course. Changed my career. It's what led me to focus my legal practice solely on use of force law. And to my knowledge, I'm still, decades later, the only attorney in the country who has that exclusive focus on use of force law. So obviously, I think the world of Massad Ayoob. Guys like me can do what I do because I stand on the shoulders of Massad Ayoob and his peers. So when I play this short, I don't want it to come across as criticism. I just want to offer a slightly different perspective. Now, for context, Moss is not a lawyer. Moss was a career law enforcement officer who also developed a deep personal interest in use of force law. And in this little 1-minute short, he's going to speak to interacting with the police in the aftermath of a use of force event. And of course, the conventional wisdom is never talk to the police, right? Just say nothing. And Moss is going to share here a slightly different perspective. When I play this, if you folks in the comments could let me know if the audio is coming through, I'd appreciate it. It's been a while since I've done this. Okay, here we go.
I recently had a case where I was consulted by an attorney in the Rocky Mountain area. A young man had to shoot and kill an armed home invader who forced his way into the young man's home. When the police got there, he followed the advice of never talk to the police. He was obviously arrested. For God's sake, he's shot and killed someone, but he's in his own home. Yeah, drug deals go bad in someone's own home and somebody gets shot. There's any number of situations that could have made that a criminal homicide. Of course the police arrested him. He was in jail for days and days and days. Finally, got a hearing. Told his story at the hearing. The judge dismissed the case. And the thing that struck me was in the courthouse hall after the dismissal, the arresting officer, the lead investigator who made the arrest, came up to that young man and said, you know, if you had just told me that night, I never would have arrested you.
Okay, so the point Moss is making there is if you talk to the police at the scene, good things could happen to you. You could make clear that this was, by all appearances, on the facts and the evidence before them, an act of lawful self-defense. And they could decide not to arrest you. No charges would ever be brought. That's a possible outcome. And Moss is saying that's what would have happened here. And it's not that I disagree with Moss. I just think it's important to understand a broader perspective here. I would agree with Moss, first of all, is an expert on these matters, right? He's been teaching them things like interacting with the police, what to say, what not to say. He was a police captain, so he was an investigator in these cases. Moss knows exactly what to say and what not to say to the police in the aftermath of a use of force event. And if you can handle that interaction perfectly, yeah, maybe you can realize an upside of talking to the police at the scene. But most people are not Massad Ayoob. Most people don't have that level of expertise of knowing exactly what to say and not say. And most people are going to say things, may say things, that could be used to incriminate them and make it more likely not just that they'll get arrested, but that they'll spend the rest of their lives in a cage. So the greater your level of expertise in this area, use of force law, the more likely you might have a positive outcome by talking to the police. But that's not most of you. That's not even 5% of you. I would argue it may not even be me. I'm not inclined to be talking to the police a great deal when they arrive on the scene, if I've ever been compelled to use force, especially deadly force, in defense of myself. So in Moss's hypothetical, he's saying, well, if that person had given their story at the scene, they never would have been arrested. Well, it's also possible if they gave the story at the scene, they might have been something that could have been made to look incriminating, resulting in their conviction. By not talking at the scene, by waiting until they were in court at a hearing represented by legal counsel, so it's really the lawyer doing the talking. Sure, they had to increase the risk that they would be arrested, but they enormously decreased the risk that they would be convicted and sentenced to decades in prison. And when I balance those two risks out, folks, I don't really care if you're arrested. My job is to keep you out of prison. If you're arrested and I can keep you out of prison, your arrest eventually turns into a funny story you tell at family events. If you blab at the scene and provide information that could be used to incriminate you, even if it has to be twisted by the prosecutor to incriminate you, misrepresented, even if in actuality you're totally innocent, but it's enough to get you convicted and you're spending decades in prison, there are no family gatherings. So that's the perspective I would add to that. Another recent question that came in, and by the way, if you're a law self-defense member, one of the benefits you have as a member is in the member dashboard, the same column that you click to open up this video, there's another tab. I think it says Ask Andrew. You can submit questions to me anytime. You can submit them confidentially, and I'll send you a confidential personal response. Or if you don't indicate that, we'll add them to the list of questions we might address in one of these shows. But that's where we aggregate questions from our members to look at in shows like this. And one of those that came in has to do with the LA fires. Now, there's people arguing. And by the way, if you don't know, I did a very lengthy show earlier this week on the LA fires. But there is evidence to indicate that the fires may not have been naturally occurring or the result of power lines, but the consequence of arsonists. And so someone asked, well, what happens if you see an arsonist? Someone, I don't know, with a Molotov cocktail or a yellow blowtorch, just, setting fire to brush or pouring gasoline and throwing a match in. Obviously not doing something of an innocent nature, especially in an environment that's known to have a very high fire risk. What can you do to stop someone who appears to be about to commit arson? And the general rule is you can shoot that person. Because the act of arson, although it seems like a property crime, right? You're setting property on fire. It's not really a property crime, and the law doesn't look at it as a property crime because of the explicit threat to humans of a runaway fire, as we've seen in this California fire, right? Thousands of homes burned down. Even if you didn't have that risk, just a house catching on fire, people die in house fires, right? All the time. So when you're shooting an arsonist, someone apparently about to commit an act of arson, you're not really shooting them to defend the structure they're trying to burn down. You're shooting them to defend the people inside the structure who'd be at imminent risk of death or serious bodily injury. And that's one of those examples, by the way, in which shooting someone at a distance might be a legally justified act. Normally, that wouldn't be the case, right? Normally, we think of self-defense as we're being threatened with imminent, unlawful, deadly force harm. Probably that person's in close proximity, and we shoot them at close proximity in self-defense, and it looks like a traditional self-defense scenario. If you shoot that same person when they're 100 yards away, how can that be self-defense? How were they threatening you from 100 yards away? Let's assume they did not have a long gun, for example. That's a harder case to make, right? But there are scenarios in which even shooting someone at a distance can be clearly legally justified. One would be if that person 100 yards away was threatening someone much closer to them, right? You see them about to shoot an innocent person in the back of the head. It's a defense of others scenario. You're defending that other innocent person. So even though you're at a great distance, you can be justified using deadly force in defense of another person. Because you're not defending against a threat to you, you're defending against a person in defense of a person who is proximate to the bad actor. Or this arson kind of situation, right? You look out 100 yards down your block and you see someone pouring gasoline around the base of a building, holding up a match. By all appearances, imminent arson is about to occur. Now, they're not threatening you, but they're threatening to commit arson. That could be a long-distance shooting that would be justified. So they do happen for sure. Same in active shooter events, right? And we've seen these. I think you've all seen these where somebody goes into a mall, starts shooting people. Well, malls have often long sight lines. You might be quite some distance away, and engage that bad actor with fire, even though you're 50, 80 yards away. Assuming, of course, you're competent to make hits with your gear at that distance. If you're not, you're just sending lead flying down a shopping mall. Another question that came up is, I phrased it as in my notes as, when is communication legally privileged so it can't be used against you in court? But let me put that in a more practical context. It came up in the context of the self-defense insurance companies. I'm talking about USCCA, CCW Safe, attorneys on retainer, any of the others. And there can be a concern. So you're involved in a use of force event. You're a member of one of these services, that you have a hotline number, just like you have for law of self-defense. If you're a law of self-defense platinum member, you get a card in the mail with our hotline number. You call us to get us involved in the case right away. But for any of these services, you have a hotline number. You call them. Someone answers the phone, or a recording answers. And now you need to say words. The words you say might either be legally privileged or not privileged. If they're legally privileged, they cannot be used against you in a court of law. And by privileged, I mean it's communication between you and a lawyer for purposes of representation and legal defense. So there's attorney-client privilege. Those communications between you and your lawyer are privileged. They cannot be used against you in a court of law. Or they might not be privileged. If you just were to call your neighbor, not a lawyer, and say, oh my gosh, I just shot somebody under these circumstances, none of that is privileged. That neighbor could be called to testify at trial under oath and be compelled to share what you told them. That can't be done to your lawyer. And it can't be done to anyone on your lawyer's staff. So your lawyer's privilege extends like an umbrella over everybody that works in his office, investigators he hires. They would all be covered by your lawyer's privilege. So in the context of law self-defense, for example, you're a platinum member, you're involved in an event, you call us, you're talking to me. I'm a lawyer participating in your legal defense. Absolutely privileged. Attorneys on retainer, you call their office, they're attorneys, they're a law firm. You may not get Mark or Andy on the phone, the partners, but you probably won't. I mean, let's face it, they'll have staff who'll answer the phone, but that staff is covered by their privilege, the umbrella of their privilege. It gets a little sketchier if you're calling one of these services that are not really law firms, and it gets more ambiguous. Now, the person who posed this question to me said they contacted CCW Safe, who I do a lot of partnering with. I'm personally a member of CCW Safe. And they say that CCW Safe told them that their communications to CCW Safe would not be privileged. I don't know if that's actually CCW Safe's position or not. I would have thought not, to tell you the truth, because CCW Safe has a permanent lawyer as part of their team. That's attorney Don West. He's their national trial counsel. So I would argue that if you're in the aftermath of a use of force event and you call CCW Safe, you're really calling Don West, an attorney, a criminal defense attorney, who will be part of your legal defense team. And so anything you say to CCW Safe should be covered by that privilege, would be my argument. It gets a lot more sketchy if you're talking to USCCA. Now, because they don't even have lawyers on staff. They have no equivalent to Don West. They don't have any lawyers on staff who would be part of your legal defense. They may have business lawyers. And in fact, in the early years, USCCA for 2-3 years, something like that, they had put together what they called a legal advisory board, and they invited 10 of us, I think 10 lawyers. I was part of that. 10 lawyers to be their legal advisory board. And we had a few meetings where we all got together with the senior USCCA staff, Tim Schmidt, and they would tell us about the service and we would provide feedback. And one of the things all us lawyers were really disturbed about was the hotline process for USCCA. Now maybe they've changed it. So I'm just speaking in the context with which I was familiar, although I don't think they've changed it. I haven't heard that they've changed it. But essentially, what would happen is one of their members might be involved in a use of force event. They'd call the USCCA hotline, and they'd be talking to a secretary, basically. And the secretary would be asking them lots of questions about what happened. Well, there's no privilege there. There's none. And of course, all us lawyers saw that immediately. We're like, holy Cape Cod. This is terrible, because that entire conversation, and it's being recorded like most customer service calls, that entire conversation can be subpoenaed by the prosecution and used to incriminate your member. We don't want any client we would be representing to be spouting off about what happened on your hotline. Now, that had never occurred to USCCA because they're not a law practice, because they have no defense attorneys on staff. They were completely blind to this risk to their members. So it can become an ambiguous question. The closer you are to actually communicating to a lawyer who will be involved in your defense, the more privilege that's going to be. But privilege can be denied if the connection to legal representation is sufficiently sketchy. The trial judge can just say, I'm not going to recognize privilege there. That person will be compelled to speak, to testify in court about whatever conversation you had with them. So hopefully that scopes that out a little more. Let's see, where are we for time? Let me take a look at some other stuff we have here. Oh, by the way, I do want to mention, periodically, every few months, we do a free webinar. This is our Hard to Convict webinar. It's about an hour and a half long, maybe 2 hours with Q&A. But as the name suggests, in this webinar, we teach you how to be hard to convict if you're ever compelled to use force in defense of yourself, your family, your property, and it's 100% free. Now, we do offer you some books and stuff at the end, but you don't have to listen to that part of it if you don't want to. You certainly don't have to buy anything. The webinar itself is completely free, and we have one coming up in just a few weeks. So we don't charge anything, but we do limit the number of seats, so we have enough adequate opportunity to answer everyone's questions without being there all day. So if this is at all of interest, I would encourage you to sign up sooner rather than later to make sure you get a seat. And you can do that at lawofselfdefense.com/HTC. HTC. Okay, so a couple things I wanted to bring up. One is, let's see how many questions I have here on this one. All right, so we did our shows of this past week. Let me talk about those. I wonder if I have that. All right, so we did a show on the LA fire. I already addressed the questions about those. Oh, by the way, I know it looks here like this, that this blog post, I wonder if we changed that, was written by Santiago Belfort. Santiago is one of our production teams. So he's the guy who posted this video up to the website for me. He did not write this. He's not a lawyer. He's a very nice guy, and he's very talented at production matters, but he did not create this content. So that's a glitch in our online system we're going to address. But the real question we got about the LA fires in the members' questions was about that arson question, which we've already addressed. Then let's see, what do we have here? We had a looting question, a looting show. We didn't have many member questions about that. We had a show about a woman cursing at the cops. That was a real pain to put those bleeps in. It's a 3-minute exchange between this woman and police officers at our front door. And I think we put more than 100 bleeps in to that 3-minute exchange. She definitely She felt strongly about those police officers standing outside her house for sure. So that was a lot of fun. And the main comment we got to this one was someone suggested that the woman in question, her name was Dawn, should record, should copyright her recording of this exchange, and I don't know, put it up on TikTok or make it available to the general public to program into their own Ring cameras for when the cops ever show up at their house. It's an interesting marketing opportunity. All of you watching on YouTube, your time with us is done. I hope you enjoyed the show. Consider becoming a member. You can stay for the rest of these shows. You could do it right now. lawofselfdefense.com/trial gets you a trial membership. You're immediately emailed instructions on how to join us for the rest of today's show and all our members only content. It's only 99 cents, folks. lawofselfdefense.com/trial. I hope you become a member. And with that, I'll wish you all YouTube. If you're a Law Self-Defense member, don't go anywhere. The show is continuing for you. But for the Law Self-Defense members, the show is over for you. So have a great weekend. Stay safe. And I hope we have a chance to meet again soon. So YouTube, you are done.